My name is Steph Lindquist. I am the Executive Director of the Center for Constitutional Design, and I want to thank you all for coming here this evening to listen to us discuss originalism and the rights of women. This is a follow-up event from an originalism event we had last semester with Justice Bullock and some other excellent scholars, Ilan Werman, who's here in the audience as well, and Jim and myself, to discuss originalism more broadly defined. But after that event, a student came up to us and said, hey, what I'm particularly concerned or interested in is learning about originalism and women and how it affects women's rights. And so this event we quickly scrambled to pull together, and we have excellent panelists tonight to discuss it with us, and I'm so grateful that you're here. As you already probably know, or at least some of you do, the Center for Constitutional Design at the law school here is a fairly new institution, about a year old, and we are focused on a mission of promoting conversations about constitutional design, amendments and reform to promote and sustain our constitutional democracy. So it's just a small task, just a small mission, but we're very, very dedicated to it. And we really have a self-conscious focus on balancing reverence for the Constitution against reform of the Constitution to ensure that our democracy survives for another 200 years. And that's, of course, ultimately our objective. Actually not on your tables, but outside on the welcome table there is a calendar of future events for the center, so I encourage you to take one of those on your way out, or take a look at our website, which is constitutionaldesign.asu.edu, where you can find information about our events there too. One other thing I'll say before moving to the panel is that we're also launching a major series of events in partnership with the National Constitution Center to explore 5 constitutional amendments that were the product of a multi-ideological group. Ilan was among them. Where is Ilan? You're hiding, there you are. Professor Werman was among them, and Professor Sheehan from the School of Civic and Economic Thought and Leadership was in that group as well. So 2 ASU, among other luminaries, who identified 5 amendments that they could all agree on, even though they were across the ideological spectrum. And so we're going to be pushing that conversation forward over the course of the year to see if we can engage policymakers and others about whether such amendments might work. They're good government amendments, one might say. So I am going to introduce our wonderful moderator, Jim Weinstein, as all of you know, a professor here at ASU Law. He is the Dan Cracchiolo. Am I pronouncing that right, Jim?
I think it's Cracciola, but I'm not.
Oh, Cracciola. Okay, I'm not Italian, so Cracciola in constitutional law. He's an expert in the First Amendment and free speech, but also in jurisprudence and legal history, and is very interested in originalism. He has written so much in so many papers and books that it would be impossible to catalog them here, but let me just say, by way of a quick synopsis, that he is highly sought after around the world. For example, this coming semester he is a fellow at Oxford University. I forget which college, Jim. University College, and is going to be visiting also at the University of Melbourne in Australia too. And that's because he has such a global reputation in his field. He has also been an incredible friend to the Center. Jim, we want to thank you for your support to the Center and for our efforts, and we're very grateful and honored to have you as our moderator tonight. So I'm going to give you the podium. Thank you, Jim.
Thank you, Steph. Generous.
Jim, let me give you this. This is insane.
Can you all hear me?
Okay.
Yeah.
I don't need no stinking.
For the recording. Yeah, he might.
No. He has one for the recording. Yes, he's so.
So.
I think it actually fell down.
Tonight I am going to.
Oh, hey Jim, wait. Stop.
Oh.
You lost your.
All right.
Is he okay?
Am I all right? Okay. Just as long as you had Steph talking about me, that's the important thing. Otherwise, so it's my pleasure to introduce this evening's very distinguished a panel, and since we have the full biographies been handed out, I am going to make it very short, and we'll introduce first alphabetically, but we will not go alphabetically in terms of speaking, but alphabetically we have Marianne Case, the Arnold I. Schur Professor of Law at the University of Chicago. Professor Case has taught courses on feminist jurisprudence, constitutional law, the regulation of sexuality, marriage, sex discrimination, among many other courses. Her scholarship has concentrated on the regulation of sex, gender, sexuality, religion, and family, as well as, pertinent tonight, the early history of feminism. And then...
Except when I say early, I'm talking about the Middle Ages.
Oh, wow. Boy, I want to hear about that. So then we have Tessa L. Dysart, who is the Assistant Director of the Legal Writing and Clinical Professor of Law at the University of Arizona, James E. Rogers College of Law. Here we call that institution the other place.
The other place.
That's when we're being polite. That's what we call. Professor Dysart writes and speaks nationally on appellate advocacy issues. She has also written on human trafficking and constitutional law, and has lectured nationally on developing effective state anti-trafficking laws. And then we have, who you've already heard from, Stephanie Lindquist, who is a professor of law and political science in the Sandra Day O'Connor College of Law and in the School of Global Politics at ASU. Professor Lindquist is a recognized expert on the United States Supreme Court on constitutional law and administrative law. And most importantly for these purposes, as you've heard, she's executive director of the Center for Constitutional Design, which is sponsoring this event, but that will get you no favoritism from this moderator. And so with that, we're ready to go. We'll start with Professor Dysart, then Professor Lindquist, and then Professor Case. Each speaker will have 15 minutes, and then we'll have 12 minutes of moderated discussion, and then 15 minutes of question and answer. So we'll hear first from Professor Dysart. And you can come to the podium or you can stay seated, whatever you feel most comfortable.
I'm going to stay here. Got to steel myself for the onslaught. All right, well, thank you for inviting me. I'm honored to be here. It's always fun to come up to ASU for an event. And I understand that I am the only originalist on this panel, so the entire defense of originalism rests on my shoulders, which is a scary thought, but I will do my best.
I should add, we had invited a second one,
yes.
but she had a family emergency.
Yes,
So she
but I've talked to her, so we've coordinated. So what I'm going to start with is...
She is Christine Sandifer.
Christine Sandifer, yes. So I'm going to start with some general principles about originalism that I hope that we can agree on, maybe to some degree. Then I'm actually going to challenge the premise of the event that that originalism cannot be squared with constitutional protections for women. And then if we have time, which we probably won't unless I talk really fast, I will talk about maybe some difficulties with doing originalism when you look at diverse populations. So let me start with general principle number one. That is, originalism is the leading theory of constitutional interpretation. And I cite none other than my former dean and friend, Justice Elena Kagan, who famously said at her confirmation hearing that we are all originalists. Now, of course, that's not the full quote, so let me read you the quote. She said, "Sometimes they lay down," talking about the framers, "very specific rules. Sometimes they laid down broad principles. Either way, we apply what they said, what they tried to do. In that way, we are all originalists." Now, I would quip with her a little bit. We can't both always apply what they said and what they tried to do. Sometimes those are different things, as we'll talk about later. But I think she recognized that, sometimes the framers use broad language. This first general principle is also bolstered by a case that I always start with when I teach con law, and that's District of Columbia versus Heller, where you see Justice Scalia in the majority and Justice Stevens in dissent, both purporting to apply originalism and applying it to lead to differing results. So this is my second principle, that originalism doesn't always lead to the same results. This might be a little bit more controversial because probably the different originalists would say, well, you're a bad, Justice Stevens is a bad originalist, or, Justice Gorsuch is a bad originalist, or whatever. But I think people in good faith can be applying originalism and come to differing results. You see that in Heller, you see that in Bostick, which was a statutory decision, but you can see originalism lead to differing results. And again, going back to Kagan's comments, some of this is because the framers did use in places very broad language that could be susceptible to multiple meanings. The example that I use the most when I'm teaching this in class, and I promise I will get to women, like halfway through my remarks, but the example I use the most is discussions surrounding slavery. And I actually have some of my former con law students in this class, so they might remember this. And I ask my students, if the Constitution, as it was originally written, was a pro-slavery or an anti-slavery document. And I think looking back today with 200 plus years of history, we would say it was a pro-slavery document. At a minimum, it supported the institutions of slavery. But the framers were very careful to not use the words slave or slavery in the Constitution. And in fact, the words race, slavery, and servitude were not introduced into the Constitution until the Reconstruction Amendments. So this vague language actually led to debates in the 1800s over whether the Constitution supported slavery. You have William Lloyd Garrison, who calls the Constitution a covenant with death and an agreement with hell. And then you have Lysander Spooner and then Frederick Douglass, who disagreed that the text of the Constitution supports slavery. And I forgot I didn't put all these quotes up here on my notes. So here's two quotes from Douglass, and I think the most interesting, he denies that the Constitution guarantees the right to hold property in a man, and he says, "It would be the wildest of absurdities and lead to endless confusion and mischiefs if instead of looking to the written paper itself for its meaning, it were attempted to make us search it out in the secret motives and dishonest intentions of some of the men who took part in writing it." So he says, look, let's look to the words that were used and we apply those particular words. And this is an important point that leads to my general point number 3, that the best form of originalism looks at meaning and not intent. So many years ago, I was writing a amicus brief in a Second Amendment case, and I spent, in the McDonald case dealing with incorporation of the Second Amendment, I spent a lot of time looking at the debates over the 14th Amendment in Congress. I've read Madison's notes about the Constitutional Convention. I have worked in prior lives in the state legislature and in Congress and the Senate Judiciary Committee, and I have a 2-year-old and a 4-year-old. So all of these experiences make me an expert to say the following. You can't know people's intent, right? So what is in someone's heart of hearts is very difficult to ascertain, even from perhaps words used on the floor of the Senate or the U.S. House of Representatives. And this is why looking at words and what those words mean is so important. And it's especially relevant when we look at the 14th Amendment for 2 reasons. First, texts could have expected or applications that are beyond the original expected applications. This is a point that Jack Balkin and Stephen Calabrese make. So the framers might have thought the 14th Amendment would work, one way, but then when the courts apply the 14th Amendment, it works a different way. I mean, we see this in practice today when Congress passes a law and then the courts rule on it, that often the expected applications don't always end up happening when the provision is ruled on. Also, and this is maybe a little bit more controversial, we, certainly among originalists, we apply the Constitution to current facts, not erroneous factual assumptions that the framers of the 14th Amendment might have had, such as their assumptions about women and the capacity of women, right? So we don't have to, those facts are not written into the Constitution, so to speak. All right, so let me go on to the actual 14th Amendment. And I'm going to present to you 2 theories of why the 14th Amendment protects women. The first, I think, is similar to what Christina would have said if she was here based on conversations we have, but all errors are my fault and not hers. So if I say anything crazy, please don't blame her, blame me. And then the second, I'll hopefully have time to get to. So like a good originalist, let's start with the text. And let me put up here the text of Section 1 and Section 2 of the 14th Amendment. And you will notice that the framers of the 14th Amendment use the words person and citizen in Section 1. So persons had certain rights, citizens had other rights. And this is there's no gendered language in Section 1, right? If there's an ellipses, I promise I didn't take out the word man. I'm a good lawyer, I didn't do that. So then over to Section 2, you see Congress did, in fact, know to use gendered language. So Section 2 deals with voting rights. It deals, talks about persons when it talks about apportionment of how many seats are given in Congress. But then it talks about male inhabitants when it talks about specifically who can vote. Then, of course, we have the 15th Amendment, where you see actual race-based language, talking about denying the right to vote based on race, color, or previous condition of servitude. So I think we can draw several conclusions from this language. First, the framers knew how to use gendered language, right? Because they did it in other places in the Constitution. Same with language dealing with race discrimination. They knew how to use that language because they used it in very contemporaneous times. Second, the place the framers were most concerned about gendered language was in Section 2 of the 14th Amendment that dealt with the political rights of citizens, namely the right to vote. Third, Section 1 of the 14th Amendment, I'm going to flip back to it really quick here. Section 1 of the 14th Amendment, in securing privileges or immunities, equal protection, and due process, does not cover political rights. Now let me pause here and say in our society today, we tend to conflate political rights and civil rights, but in the 1800s, it was more relevant to set them out. So people had, women and children had some amount of civil rights, and then political rights were sort of the pinnacle. Like once you had political rights, you were assumed to have all other rights. Now we can debate what's a political right. We won't talk about social rights. Professor Werman doesn't believe those exist. We could talk about, what falls into different categories. I don't think that's entirely relevant for our discussion today, but I want you to see that there's this distinction between civil and political rights. So Section 1 was designed to protect civil rights, not political rights. Because if it was designed to also protect political rights, then Section 2 would be superfluous, as would the 15th Amendment, right? We read the Constitution to not have surplusage. So Section 1 deals with civil rights, Section 2, and then the 15th Amendment deal with political rights. And in protecting these civil rights, the framers used general and not gendered language. Now, the fact that many of the framers were concerned about race-based discrimination is irrelevant because they chose to use this broad language. And in fact, in the first draft of the 14th Amendment, which I'll put up the slide in just a minute, they actually did use the word race. So an initial draft of the 14th Amendment included the word race, and subsequent drafts that wasn't included. And Professor Riva Segal has explained that women's rights groups actually didn't oppose Section 1 of the 14th Amendment because they thought that it would protect their civil rights. Now, of course, the Supreme Court did not interpret Section 1 in this manner. The most egregious, we don't want to start labeling the most egregious Supreme Court cases. We could be here all night. But one of the more egregious Supreme Court cases in that line is the Bradwell case, where Mrs. Bradwell versus Illinois, she wanted to be an attorney. She was a married woman. And ultimately, she wasn't allowed to become an attorney. Justice Bradley's concurrence, where he says, I love this quote, "The paramount destiny and mission of woman are to fulfill the noble and benign offices of wife and mother." Very, very infamous quote from that case. Now, that case was styled as a privileges or immunities case and not an equal protection case. Whether that would have made a difference is interesting. There was also some interesting kind of ethical things to think about. So, for example, Mrs. Bradwell's attorney her case was argued a few months before the Slaughterhouse decision was released, and her attorney also represented the state of Louisiana in the Slaughterhouse cases, who would have wanted a very narrow reading, of course, of Section 1 of the 14th Amendment, which raises, we'll leave it there, interesting questions. So anyway, under this theory, an originalist look at Section 1 would protect the rights of women, the civil rights of women, under meanings that were given to those words at the time and that at least some people understood, but the courts, of course, got it wrong, as they're known to do from time to time. All right, let me move on quickly to my second theory, which is really the Stephen Calabrese, Julia Rickert theory, not my theory. So, give them credit. They have an excellent lengthy law review article called Originalism and Sex Discrimination in the Texas Law Review. So they argue that Section 1 was intended to prescribe class-based legislation or any law that makes a system of caste. And they point to, here's this first version of Section 1 of the 14th Amendment. It's very similar to what we actually see in the 15th Amendment, except using the language of civil rights. And in moving away from this language, members of Congress and others wanted the new language to be more about abolishing a system of caste. So let's get it up here. So now we can argue, and there may be questions about this, of what provision in Section 1 is aimed at this anti-caste legislation. Is it equal protection? Is it privileges or immunities? It's a great debate, very interesting. Not relevant, though, for the ultimate theory, that the Section 1, some portion of Section 1 was designed to address this caste-based system. So was sex discrimination considered a caste at this time in the 1860s? And Calabresi and Rickert say that there was consensus around the statement that if sex discrimination was the equivalent of race discrimination, then it would be protected by the amendment. And they say using the interpretive methodologies in the 1860s, they find that, in fact, yes, there were, not everyone, but there were certainly voices, in the press and such, and in Congress that talked about sex discrimination and compared it to race discrimination. They, of course, make the point that like I said earlier, in interpreting the 14th Amendment, we are not, again, bound by the erroneous factual assumptions made by the enactors. 1 minute. All right, so let me go for it. Their argument is bolstered, they say, by the passing of the 19th Amendment, which if you note, specifically deals with just the right to vote. So the 19th Amendment says nothing about the civil rights of women. It just clarifies that gendered language in Section 2 of the 14th Amendment. And so they say that, 60 years later with the passing of the 19th Amendment, that really seals the understanding of the 14th Amendment in protecting against sex discrimination. And then finally, and this is horrible pedagogy to put this big of a quote on the screen, and I apologize, but you don't have to take my word or Stephen Calabresi's word. This is Justice Sutherland in the case Adkins versus Children's Hospital, dealt with minimum wage for women and children, and specifically saying, look, this is the 2023 version. Hey, look, the 19th Amendment changed things, and society is changing, and so maybe we had these outdated views, back then, but now we can say that women shouldn't be given any sort of special protection. So that's that. I'm happy to answer questions. According to my clock, I have Jim only 15 seconds over. So there we go.
All right, well done. Substantial compliance. Okay, now we'll hear from Professor Lindquist.
Okay, great. Well, thank you so much, Tessa, for that exposition of the 14th Amendment and how it can, even under an originalist interpretation, protect women's rights. I'm going to take a step back and focus on what originalism purports to offer to us. The reason that originalism has become so popular among some segments, and there's many different sources of originalism in terms of the historical record, why it has become so popular of late, et cetera, and we can talk about that. But one of the major reasons that people pursue an originalist methodology is because they believe it is a foolproof way, or at least one important way, to eliminate judicial discretion. If you are looking back at the original meaning at the time that whatever provision in the Constitution, either in 1868 or in the late 1700s, then you are, by virtue of evaluating the meaning at the time that those clauses were adopted, you are able to constrain what is otherwise unfettered discretion by judges when they apply a methodology that is less, in the view of originalists, less constraining. Kent Greenawalt called this the elusive quest to find the fetters that bind judges. And I believe he was right, that it's very elusive. And I want to just say, make basically 5 points about originalism that I think sort of condemn it to the same pool of interpretive methods that fail to constrain judicial discretion as every other one. And that is true in the case of women's rights as well. In fact, I was talking to my students the other day about mercury. And a case involving mercury came up. It was an environmental case. And thanks to some of my students for being here. I know some of them are out there. Mercury is a thing that it slips through your fingers, but maintains its integrity no matter where it ends up. And I always think of discretion by governmental officials sort of fall in that category. No matter how hard you try to squeeze it out of one decision-making process, it lands someplace else. Discretion is hard to push out of the decision-making process. So 5 points I want to make. First, originalism has a problem with faint of heart originalists who deploy what I call hard-hearted originalism selectively and only when it's politically feasible. If you have faint-hearted originalism and hard-hearted originalism all sitting on the same court, and some being hard-hearted, some being faint-hearted, then the argument that originalism actually constrains discretion goes out the window. In fact, there is only one hard-hearted originalist on the court today, in my opinion, and that is Justice Thomas. The other conservative justices are largely faint-hearted originalists like Scalia was. A hard-hearted originalist commits to an unwavering fidelity to the Constitution as we find it, unsullied by centuries of precedential gloss that could have contradicted the original meaning of the Constitution. And hard-hearted originalism, notwithstanding the very able arguments made by my co-panelist here, is very bad for women. At least with respect to abortion, hard-hearted originalism produced the Dobbs decision overturning Roe versus Wade. That was really hard-hearted originalism, in my opinion. And the reason it was hard-hearted originalism is because the justices went back to the early periods in our history and concluded that by looking at state laws, et cetera, and the prevailing understanding of those laws, that the Constitution simply did not protect abortion rights as understood to be either rights or liberties of any kind early in our republic. And it's unlikely that abortion rights could be rescued by the 14th Amendment either, rather than the word liberty in the Due Process Clause, because the amendment simply does not apply. And I hearken back to Bradwell versus the state of Illinois as well, which was decided in 1872, 4 years after the 14th Amendment was ratified. And so looking to the understanding of the rights and liberties of women at that time, we can really find quite a lot of sort of original meaning in the Bradwell decision itself. It was a privileges and immunities case rather than an equal protection case, but the sentiments about the legal status and rights of women at the time are on sharp display there. And I won't reread the quote that I also had in my notes, by the way. But that certainly, if there was an original meaning about what women could do, it was demonstrated in the state laws that were extant at the time, which did not permit women to practice law and had a number of other restrictions on them. And it certainly is reflected in the way that Justice Bradley perceived women's scope and abilities at the time were. Thomas is a hard-hearted originalist, but Alito is generally not, because in Dobbs, what Alito said was that the sexual orientation cases, Lawrence versus Texas, Obergefell versus Hodges, et cetera, were not under threat of being overturned as a result of the Dobbs case. That is faint-hearted originalism, because a hard-hearted originalism, as we saw in the Thomas case, would clearly have would have concluded that those cases also need to be overturned. And the minute you deviate from hard-hearted originalism, originalism then loses its power as the ostensible constraint on judicial discretion that it is, because it's only then sort of applied as convenient. And what Alito did in the Dobbs case was to apply hard-hearted originalism, the true sort of core of originalism, only in the context of abortion, but not in these other cases, or at least that's what he professed in the opinion. Faint-hearted originalism also has a levels of analysis problem. In international relations, we think of the levels of analysis as individual, group, state, system. In the context of constitutional law and the interpretation of the Constitution, and in the context of originalism, we can think of originalism as reflecting upon the application of that particular provision as it would have been applied at the time it was adopted, as opposed to moving up a ladder of abstraction and saying that, well, indeed, yes, they might have applied that provision to eliminate or discriminate against women, not allow women the full scope of their rights as we see them today. But if we move up the ladder of abstraction, what we see is an anti-caste, however you pronounce, anti-caste element to the Constitution. And suddenly we've moved away from, I think, the way that a hard-hearted originalist would interpret the Constitution, which is what would people sitting at the time of ratification thought that amendment would actually do in the real world? How would it apply? But if you move away from that, you've moved away from the constraint, because suddenly now you're looking to broader values in the Constitution, and those can apply in a number of different ways and enter the mercury, if you want to think of it that way. So the mercury of judicial discretion can't be squeezed out of the equation, especially if you choose, for convenience, frankly, in order to ensure that women have the rights that we agree they need today. But you still want to stick with originalism, you need to move up that ladder of abstraction. Also, originalism is a fig leaf for conservative, results-oriented decision-making. I have challenged more people than I can count to name a case in which the originalist approach, as applied by the conservative justices on the Supreme Court, has produced a liberal outcome. Originalism, maybe there is, and so I'd love to hear from you. So maybe one.
Busted.
It's not a constitutional case.
So there you go. Originalism is very appealing to conservatives, especially at evangelicals. There was just a wonderful article in the New York Review of Books by Linda Greenhouse in which she cites a survey in one of the books she's reviewing that evangelical Christians in this country, 80% of them support originalism as the appropriate method of constitutional interpretation. Now that says a couple things. One is that originalism sounds good to many people. It's not clear they understand it, but it sounds good to many people. And as amazingly as a matter of constitutional interpretation, it has worked its way into the public psyche. And this is because it stands for something. It stands for conservative results. According to a recent APSR paper I read, which I have here if you're interested, originalism has been invoked in every GOP party platform from 1992 to 2016. There was no GOP party platform in 2020, as we know, for reasons I'm not going to get into here. So one of the challenges for originalists is to provide the theories apolitical. The key to an apolitical interpretive approach is that it should be said not to put a thumb on the scale of a particular kind of outcome, liberal or conservative. And it appears that when liberals do try to rely on originalist evidence, it gets them nowhere. And what that reveals, and political scientists like myself have done numerous studies, is that no matter what interpretive method you're following, and justices vary on this, but generally speaking, no matter what interpretive method you adhere to, you cannot squeeze the mercury of ideology out of Supreme Court decision-making either. How are we doing?
5 minutes.
5 minutes. Oh, good. Plenty of time. And one study I found, done by two political science buddies of mine, actually sought to test whether or not reference to originalism in a Supreme Court opinion actually would drive outcomes that were not already clearly determined by the ideological predisposition of the justices. Here's what they said, and I've done similar studies on federalism. The conservative justices love federalism unless a liberal statute is at issue, and then they'll strike that state statute down quick as you can say Jack Rabbit. Okay, so in this study by two political scientists, and it's from 2002, it should be extended, but again, what they do is they code the briefs for the presence of originalist arguments, and they conduct a sophisticated statistical analysis to see if those actually drive outcomes in these cases. And so here's what they say at the conclusion, and you're more than welcome to my copy here. Our results do suggest, to no one's surprise, we hope, that originalist dreams of a neutral method of constitutional interpretation that can remove judicial bias remain illusory. Instead, the results show that ideological predispositions to vote a particular way overwhelm Supreme Court decision-making, regardless of whether or not one premises it on an originalist interpretive method or on some vague notion of justice. So the idea that originalism constrains, it's very convenient that it is actually completely collinear with ideology for those who adhere to it. Two more points and I'm done. One is, I'm not 100% sure, and maybe Elon can help us with this, I'm not 100% sure that originalism is actually necessarily originalist itself. I have yet to see dispositive evidence that the framers themselves believed that originalism was the way to interpret the Constitution, and I've seen some contrary evidence to that effect. Jefferson, for example, said, "Some men look to constitutions with sanctimonious reverence and ascribe to the men of the preceding age a wisdom more than human. 40 years in government is worth a century of book reading, and this, the framers would say themselves, were they to rise from the dead." Now, Jefferson's not the only one speaking to this issue, but I'd like to see more evidence that the framers, heck, if they were really committed to originalism, why wouldn't they put it in the Constitution? Amendment, well, it would have been Amendment 11. We are going to recommend future generations interpret this Constitution according to our intentions. I don't think that's what they thought at all. And finally, I want to say hard-hearted originalism would produce unjust results. And you only need to look back. Certainly, originalism is grounded in the theory that the only way to change the Constitution is through constitutional amendments. But sometimes justice demands a favorable court outcome to protect rights, even if those rights would not have been recognized by the framers. And here I have Brown versus Board of Education is the obvious example. This causes all kinds of pretzel making for originalists because it's very difficult to square Brown with originalism. This obviously tripped up Bork in his confirmation hearings. And so I think this is a real issue. If the African Americans in the South during Jim Crow had had to wait for a constitutional amendment, they would have been subject to abuse and injustice for many decades thereafter. Now, the Supreme Court wasn't the only branch of government that had something to say about desegregation, desegregating schools. Thank goodness the federal government came in after the fact with primary and secondary education acts that really did promote integration. So I'm not saying they did it all by themselves, but certainly they had a significant role to play in ensuring that we recognize the fundamental rights of African Americans in the South during Jim Crow. So thanks, I'll stop there.
Thank you, Professor Case.
Thanks so much. I have the ladies of the year, I should say, and much of what I've been talking about is taping from an article I published about a decade ago called "The Ladies Forget About Them, a Feminist Perspective on Originalism." You saw that our, unfortunately, outnumbered blacks, unfortunately outnumbered given position she's propounding. A defender of originalism on this panel called her piece "Remember the Ladies." Can I ask you to nod your head yes, to shake it no, if you're familiar with the source of both of our votes? Okay. So I'm particularly delighted to be here at the Sandra Day O'Connor School of Law because she is one of the three people I think best equipped to speak to this. And I don't do PowerPoint, I do old-fashioned visual aids. So I've got old-fashioned visual aids representing the other two. We've got here a replica of one, actually, it's the identical piece, but it's just not hers. One of Ruth Bader Ginsburg's collars. Not her dissent collar, although I'm sure she would be dissenting on who would originalize. The other thing I'm wearing is also a replica. It's a replica of a piece of jewelry John Adams gave Abigail. And it shows her, I choose to interpret it as Abigail looking out to the horizon, waiting for her ship to come in. And her ship is never going to come in if we count on originalist methodologies to get us there. Now, I should say that this is a historically contingent fact, right? An originalist methodology applied to the Canadian Constitution, which was of extremely recent vintage and had feminists among its framers, would yield very different results. So I'm going to talk about why originalism is bad for women in the U.S. Constitution, and time permitting, I will also talk about why, in any event, I think originalism is a terrible idea as a methodology, just from my perspective as a lawyer, in a way that is not as tied to the particular results for the thing I most care about. And I am a single-issue voter when it comes to the rights of women. I have described myself elsewhere as a feminist fundamentalist, combining feminist fundamentalism as a commitment to the equality of sexes, beneath as strong as deeply rooted and which I am as unwilling to compromise as a lot of people are their religious beliefs, including in some cases religious beliefs about the subordination of women. So I know this is a panel about the 48th Amendment. I have to, though, begin with the Abigail Adams, right? Because the problem of originalism and women has existed since before there was a Constitution. Abigail Adams and John had a really good marriage. She wrote to him and said that you're writing this new Constitution, and I do beseech that you would remember the ladies in Code of Law, which I suppose would be necessary for you to make, and be more generous and favorable to them as your ancestors. Do not put such unlimited power in the hands of husbands. Remember, all men would be tyrants as they could, if they could. Now, I raise this because it seems to me good evidence against the one originalist defense of women in our first speaker's comment. Most of what our first speaker said, I hope he noticed, was a textual defense. And I agree that we are lucky. We feminists and we Americans. But the text of the Constitution absolutely is not bad for women. It becomes bad when the text is limited to interpretation along originalist methodologies. Any originalist methodology, I've heard an original and the series of originalist philos. That is to say, whether it's the intent of the framers, the original public understanding. And we've already heard about the original public understanding that women clearly didn't get the right to vote immediately afterwards. They took decades before they did that. They couldn't even get the right to become lawyers immediately after the formation of the 14th Amendment. What I want to suggest to you is, first of all, this is not an oversight. And the fact that we think differently about the rights of women is not, as Steve Calabrese has tried to argue, because we suddenly discovered that women were capable and smart and worthy of respect. Read the letters of John and Abigail Adams, or if you're a fan of musical theater, listen to their incorporation in the musical 1776. John respected the hell out of it. He didn't need to be told that she was smart, and he didn't say women are not capable of equal rights. He said it would be dangerous to give them. Right? So one of the things I argued in this earlier piece is that the decision not to give women rights is akin to decisions like the separation of powers, like on the like federalism, right? It's about the allocation of power. And what John Adams says is, if we gave you power in public, we would be completely dominated by you because you already have so much power in private. And he compares this to, says kind of, everybody's rising up, right? The Negroes are rising up. Insolent apprentices are rising up. But now I hear the women are rising up. Oh, here. I can't have that. Things don't get better by the time we get to the 14th Amendment. If other people than I, like Lee Vanderbilt, have done work on the arguments in support of the 14th Amendment, and that, again, he's what people absolutely understood the capabilities of women. And also, we're not new to claims that women should have equal rights. Seneca Falls Declaration preceded the ratification of the 14th Amendment, for example. And many of the abolitionists were also suffragists, including Frederick Douglass. So here's just two samples about whether the 13th as well as the 14th Amendment can be seen to liberate women. What is that? What is the meaning of the phrase "in voluntary servitude"? What is that? And that is, what is its intent? Simply to liberate the negro slave come his master. That's all there is of it. Will anyone undertake to say that it was to prevent voluntary servitude of my child, of my apprentice to me, or the quasi-servitude to which the wife, to some extent, owes her husband? Certainly not. And another one said, the parent has a right to the services of the child, the property of the service of the child. A husband has a right property of the service of his wife. It's the right to the management of household affairs. All of these rights rest upon the same basis as a man's right of property into service of slave. This is clearly and distinctly defined by the law and is clearly and distinctly recognized by the Constitution. Okay, so again, this is not akin to, for example, Justice Alito's favorite famous originalist quote. In an oral argument, he said to Scalia wants to know what James Madison thought of video games. Would he have enjoyed them? We didn't have video games. We did have competent women claiming their rights, and there was a deliberate decision not to give it to them. And that, unfortunately, is a decision that makes originalist claims about the rights of women unwinnable. And our originalist tender said, okay, fine, what about the 19th? And quoted, actually, an opinion that I was on my side of the debate, which is, so the 19th Amendment gave women the right to vote. Paradoxically, he has led people who otherwise have supportive constitutional claims for women's rights to say, they don't read them anymore. Now that they have a franchise, if they want equal rights, they can go vote for them. But I think it is unfair to ask of only a segment of the population, a task, if you will, to waste their energy getting up to the baseline where everybody else starts, rather than being able to use their votes for the other things they may care about, going near equal rights. Now, if I still have time, I want to say a few words about why I think originalism is both a terrible methodology and an interesting methodology favored in the United States and favored by evangelical Christians. It's interesting to me as a comparativist that I'm aware of no country that take it seriously originalism, that even in constitutional interpretation, that isn't also Protestantatory. And there is, I think, a strong analogies between originalism and biblical literalism. But there's analogies, I think, great. I will talk about what those analogies are in a moment. Those analogies, I think, great then, because I understand perfectly well why a biblical literalist would be interested in the original understanding of the author of the document. The author is gone. Whatever we may think of the framers, they are not gone. And their original intent should not lead us. Their original public understanding should not find. Now, I think there are similar kinds of problems with originalism and biblical literalism, whether you are a Jewish, a Muslim, or a Christian biblical literalist. These are documents that are produced over a period of time by multiple individuals. I mean, conceitedly, in the case of the Constitution, there isn't a claim that there is a guiding thread behind it all. And one of the problems originalists had is figuring out what to do with the 14th Amendment and how the 14th Amendment can be read back against the original Constitution, the original Bill of Rights. It also ends us fixed in a period of time. Now, if you are a devout believer in any of the religions of the peoples of the book, the reason for picking that point in time is perfectly clear. If you're Christian, it is the moment when God chose to walk upon us as a man. If you are a Jew or a Muslim, it is the moment in which God chose to send us his prophet, his wanted. Again, I have great respect for the framers, even especially John Adams, but they're not in that class, and the time of the framing is not the same kind of moment Caesar finds. It is the case, and I do a lot of work in the theological element. It is the case that most of the religions of the peoples of the book have a hard time, as do originalists, with respect to the American Constitution, updating so as to give women the rights that we now think they should have. Well, I'm by saying textualism seems a much better methodology for achieving this. And one of the other problems with originalism is that unlike other methodologies, which ask us lawyers to think about questions related to law using methodologies related to law, originalism amounts to antiquarianism, and I have a great deal of sympathy with that judge, whoever he is. We sit completely outside a sector in many cases. I need to hire a historian. I don't know if it is a periodism on its goal we want in the present and the future.
Thank you. Now we'll have some moderator discussion, but I think in all fairness, we should give Professor Dysart some reply time. And we have about 12 minutes, but you can have the lionesses share.
Okay. Well, someone stop me when I go too long, but lots to say here. So I think textualism is certainly a part of originalism, because in doing originalism and coming up with the original public meaning, you would naturally have to look at the words and what they mean. And so I would, go back again. I guess I would quibble with saying it was a deliberate choice to exclude women when they deliberately didn't use gendered language. Sorry. It was a deliberate decision. A deliberate decision to, sorry.
Yeah,
I don't want to.
It was more than their lack of gendered language. It was,
Okay.
I mean, Abigail said, do this, and John said, funniest thing I ever heard, and I know better than to do that. If you really are going to rise up, then General Washington and all our brave soldiers will fight you.
And was that with the Declaration or with the Constitution?
Constitution.
Because I thought he was in France in the Constitution, but I could be wrong.
He wasn't. I'll give you the date.
Okay, I'll say a few other things. So I think another important thing and the impact of the 19th Amendment is once women received the right to vote, so once someone had political rights in society at that time, you were assumed then to have all civil rights. And so there didn't seem to be a need to lay out that, oh, by the way, you also have these equal civil rights, just the way the rights were considered at that time. In terms of, let me maybe say the thing that I didn't quite get enough time to say at the end. There's a difficulty in looking at, I think, older Supreme Court opinions with the notion of originalism. So what did they know in 1872 about what, women's rights newspapers were saying, or Native American newspapers were saying, or, newspapers serving the Hispanic community were saying? Probably not a lot from the justices on the court. And one of the neat things I think about originalism now is the corpus linguistic movement and the efforts to have, a wider variety of sources to look at and looking at original public meaning. And this is one of the points Christina Mulligan raises in her article on diverse originalism, that, we didn't always have the most diverse voices to consider when looking at original public meaning. And something that I think originalists could do better at is seeking out more diverse early sources. But there are early sources. There were certainly people who thought that Section 1 of the 14th Amendment did give women equal civil rights. Now, maybe those people weren't vocal, in Congress, but in looking at the words, there were certainly people who thought that at the time, just like there were people, even pre-Lysander Spooner. Mulligan talks about a writer from 1799 who actually espoused the same view, that the Constitution did not support the institution of slavery because it didn't use those specific words. Parts of the Constitution, when we look at meaning, sometimes the framers had very specific things they said in the Constitution, and I cannot believe I do not have a copy of the Constitution with me. I almost always have it when I give speeches on the Constitution. It's got George Washington on the cover, so I say it's like the original version, and it's got a lot of kitty bite marks in it because my cats seem to think it's tasty as well. But you look at provisions that talk about, Congress has to create post roads, for example. Okay, that's a very specific provision. But then you can sort of interpret it on, well, then they can also criminalize, stealing the mail, and there was that big debate in Congress over the post roads. The Equal Protection Clause, privileges or immunities, due process, those are very vague, broad statements, and determining there were differing views on what those particular words meant, and I think there could be several original public meanings of different communities of what those words meant. I guess as a judge, I'm not a judge. If I were a judge, I would rather at least look to what other people thought than my own made-up, tired mommy views because I didn't get enough sleep last night. So I think I'll maybe leave it there. I will say Michael McConnell, love his work, has a great originalist defense of Brown versus Board of Education that I think is very interesting. and I was trying to think of anti-originalist or anti-conservative originalist opinions, and my best one is Employment Division versus Smith.
What about some other Scalia Fourth Amendment? Doesn't he come out protecting against search and seizures?
Kelo
But not for.
or Kylo?
But not for any kind of electronic surveillance.
Well, but I think he does come out with liberals. When he,
Yeah, true.
and I should also say, because I often like to see agreement, maybe between Professors Dicer and Case, about textualism. I understood textualism to be a type of originalism. Scalia is a textualist, but also an originalist. Thomas is less textual, I think, and you see them battling sometimes. But
Well, so I think sometimes the words are more clear than others, and so I mean textualism, tools that originalists use. You look at the text, you can look at structure, you can look at history. There's many, which is in part why, flipping back to my slides, I looked at the 14th Amendment in juxtaposition with the 15th Amendment in sections 1 and sections 2. So those are certainly tools that originalists use in interpreting the Constitution. I mean, there's lots of tools out there.
Textual, I know of no lawyer who does not use textualism, right? You can't conflate originalism and textualism. Everybody thinks the text is relevant. And again, we are lucky, we Americans, we women and feminists in America, that the text is not our problem. Other texts in other documents could be our problem. I just want to correct myself. It is the case that Abigail was writing to John at the time of the Declaration. She kept writing until 1782, but she was writing even in 1776 about the future code of laws she thought that the new nation would need. She was not talking about the Declaration.
I'll just say something more about textualism as originalism. As Scalia used it to move away from this intent, it's text as understood by the original public meaning. And that's where it does, if you use your word, conflated. So that type of textualism is the Scalia type of textualism that relies on original public meaning is a type of originalism.
And I think it's consistent to what Kagan was talking about at her confirmation hearings and what you see increasingly. I mean, when I took con law, my textbook did not start with the Constitution. We read very little of the Constitution in reading constitutional cases. So I think until Scalia and Bork, and you can look at Ed Meese and some of those individuals came to prominence, there was a time period where the actual words of the Constitution were not as important in judicial decision making. But that has not been the case in the last, I would say, 30 or 40 years.
And here is what Scalia himself said on the question of originalism and women. He walked it back later, but so incoherently that it's clear that he originally, no pun intended, meant what he said. He was asked by interviewer Calvin Massey in 1868, when the 13th Congress was debating and ultimately proposing the 14th Amendment. I don't think anybody would have thought that equal protection applied to sex discrimination, or certainly not to sexual
Request for you to
orientation.
speak up, please.
Okay, I don't think that anyone would have thought that equal protection applied to sex discrimination, or certainly not to sexual orientation. So does that mean we've gone off in error by applying the 14th Amendment to both? Scalia's response, yes, sorry to tell you that. But if indeed the current society has come to different views, that's fine. You do not need the Constitution to reflect the wishes of the current society. Certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that's what it meant. Nobody ever voted for that. Now, who was voting, of course? If the current society wants to outlaw discrimination by sex, hey, we have things called legislatures, and they enact things called laws. You don't need a constitution to keep things up to date. All you need is a legislature and a ballot box.
So that's where he was being a hard-hearted originalist for that brief period. But then he became a faint-hearted originalist.
Right, and even
Yes.
there he was wrong. He said he didn't mean it, and it would be unconstitutional to give women different sentences for the same crime. Hate to break it to him, but that was the practice from the time of the framing of the 14th Amendment to well into my lifetime as a lawyer. Men tended to get determinate sentences, which in practice turned out to be shorter. Women tended to get indeterminate sentences, which in practice turned out to be longer because they were supposed to stay there until they were rehabilitated, which could be a very long time.
I will just say, not everything Justice Scalia said, absolutely correct. So I don't think he's he's a very prominent figure in originalism, but goes back to, originalism doesn't always lead to the same results. There's different branches of originalism. I think Justice Scalia has been wrong, or was wrong, many times, and that would absolutely be one of them.
So can I ask, this is a sincere question, it's not a
Yeah.
strategic rhetorical debating point. So it seems to me that your last set of comments, which is, there are other people out there saying other things, are in serious tension with the Calabresi argument, which is that the only way we can save originalism for women is to say it didn't dawn on people until recently that women deserved rights. But also, B, puzzles me because, of course, at any point in time, there are different opinions about everything. The point is that in framing the Constitution, some people won and some people lost. And these people were losers.
So Calabresi does talk about, specifically in talking about the instance of sex discrimination as a caste, that there were some voices that equated sex discrimination as a caste and some didn't.
And they
so
got shouted down. They got outvoted. And people said, we hear you, but you're wrong.
But again, I guess I would say they didn't necessarily when you look at the words. So their words. So let's look at the example of the necessary proper clause in McCulloch versus Maryland, right? You have the framers of the Constitution debating about whether Congress should have the power to incorporate. They say no, they don't give Congress that power in Article 1, Section 8. And then, 30 years later, you have the Supreme Court saying that, in fact, yes, Congress does have the power to charter a national bank. And so there's expected applications with the framers. This is why I'm not an intent person, right? I never know what my 4-year-old intends or my 2-year-old intends. Like, trying to ascertain someone's intent is very difficult. So we don't look at the intent, we look at the meaning of the provision, the meaning of the words used, and we look at the facts as they are now, not erroneous factual assumptions that were made. So you get
What's the erroneous factual assumption?
about the capacity of women.
Who had that? No one.
Justice Bradley had it.
No, he did not have an erroneous assumption about their capacities. He had an erroneous assumption about the place God intended for them, which was in the home. He did not say they're incapable of being good lawyers. He said that's not their job.
Marianne, do you want to look
That's like.
We've got a bunch of students here. Let's go to some Q&A.
We're going to go
running out of
to
time.
Q&A now, and we're going. I've been instructed. I think it's right too. We've been hearing from professors, so we're going to hear some questions from students at first, and maybe we'll get around to professors or people who look older than students. So, yes.
Ladies, thank you for the presentation. My name is Bo Ressa.
Yeah, go to the microphone. Yeah, it'd be best.
Sure. My name is Bo. I'm a 1L, so forgive me if you've answered this question, and I just haven't caught it. But it seems to me that a piece of law, if we treat the Constitution as having legal authority or a piece of law, something can only have authoritative command over a community if the meaning of the words are constrained to something, like whether it's the original meaning. I don't know if that's the only constraint. If basically text is not constrained by original meaning, what constrains it to prevent it from being kind of spooling out of having no weight, no authority? Does that question make sense?
It does. I'm happy to answer, but go ahead.
No, go for it.
That is a supposition or the foundation of originalism, that the only way to constrain judicial discretion in interpreting the Constitution is by virtue of recourse to the original understanding of those words at the time they were adopted. But I would argue there's many other ways to interpret a constitution. It's not that that meaning is not irrelevant, is irrelevant to interpretation of the Constitution, but there are many other factors at play. The text obviously must come first, even before original. I would put that as paramount, and the text itself, if it does have levels of abstraction that we've seen in the conversation today, where you move from what would the application have been in 1868, instead of what do the words mean more broadly defined, what was the value being embodied in those words, that has more temporal flexibility, I would say. So you have text, you have the original understanding, it's fine, throw it in the mix. Structure, precedent, all those things can come into play. Nothing is going to perfectly constrain judicial discretion, I'm sorry. That's why we have an appointment process. That's why we have advice and consent of the Senate. That's why we have presidents change hands and nominate new justices. Justices are deciding cases on a discretionary docket under certiorari. They're going to get the most politically charged cases, and there will be divided opinion about how they're decided. And it's not that it's politics all the way down. I do believe that restraint matters. Justices have varying degrees of positions on judicial restraint, but we have to appreciate the fact that none of this stuff is perfect, and that there are a variety of ways. That's my opinion.
Thank you. So I just would like to know if our dissenters dissenting from originalism would change their stance on originalism or become originalists if there was an equal rights amendment to the Constitution.
I think I've already answered that question by the last half of my remarks, which is I think originalism is a bad method as currently practiced, as any way I've seen it argued to be practiced, let alone actually practiced. I don't think we advance the ball by digging deeper and deeper into the archives of a particular point in time, rather than doing the kinds of things lawyers, frankly, over all of the rest of the world do in interpreting their constitutions and other authoritative documents. Again, as a comparativist, I point to the French Civil Code, which was ratified about the same time as the Constitution, and as no one has thought that an original understanding of the French Civil Code should govern the interpretation of the French Civil Code. And I agree that there is a serious doubt that the framers would have adopted an originalist methodology. In the case of the French Civil Code, the framers specifically say they repudiate an originalist methodology. So, lots of legal texts, including constitutions, get interpreted without recourse to originalism. Ours did until very recently. I mean, originalism is an invention of my lifetime, right? The 1980s is the first time we talked seriously about originalism as a methodology.
Actually, I brought this neat article that was just published in the APSR, tracing originalism back to post-Brown, and that it was a reaction to Brown, and so I didn't realize that, but anyway, to your point of how old it is, it's not very old, but it's certainly related to Brown.
I mean, we got along for the first 100 or more years of the interpretation of the Constitution without anyone saying originalism is the only way to interpret it.
Here's James Madison in 1824 in a letter. What a metamorphosis would be produced in the code of law if all its ancient phraseology were to be taken in its modern sense. He goes on to say that dictionaries are this wonderful thing because we can resort to the authentic meaning attached to the text at the time it was enacted. Anyway, I've done kind of, H. Jefferson Powell has this famous article in 1985, The Original Understanding of Original Intent, where he basically says, originalism is self-refuting because the founders themselves didn't expect their intentions to govern, but people forget that in the second half of that article, he says, what did they expect to govern? The original public meaning of the text that they enacted. That's H. Jefferson Powell in 1985. I've done a lot of research in the archives in these letters. I have not found a single statement that the Constitution should be interpreted as a living, breathing document until the Progressive Era.
Still a generation before originalism.
It is a constitution we are expounding that has been misinterpreted. Marshall was not talking about living constitutionalism. Anyway, so this is just an example of that originalism is sort of how they always did law. I suspect maybe they shouldn't, but I think it's a very dubious claim that the founders themselves were originalists. But I do have a question in support of Professor Dicer. I think she should stick to her guns. Why does it matter? So this is for you or anyone else. Why does it matter what they thought in 1868 about women? It matters what they thought the meaning of the Privileges or Immunities Clause, which is the correct clause, by the way, okay, meant. It meant states could regulate rights like contract, property, guns, but it can't discriminate in the provision of those rights, right? That's why the black codes were unconstitutional. Why? Because that's an abridgment, not a regulation. How do we know that? Because skin color has nothing to do with the reason for contract rights or property rights. It's not reasonably related to the purpose of the right. It's why a gay code. You don't have to decide that being gay is a suspect class. It's a silly question. Why is a gay code unconstitutional? Because being gay has nothing to do with contract rights or property rights. It's equally as unconstitutional. A Catholic code would be equally unconstitutional. Okay, that's the meaning of 1868. Okay, but we don't live under that Constitution anymore. We live under the Constitution of 1920 and the Constitution after that. The question is, what does the 19th Amendment do? What is the legal effect of giving women political rights? And as Professor Dicer says, giving political rights, it was the highest form of rights. Once you have political rights, it is presumed to be unreasonable to discriminate in the provision of civil rights. So I guess, Professor Dicer, why do you care so much about what they thought about women in 1868? Doesn't it matter what they thought in 1920? In other words, I'm trying to defend you here. Why didn't you stick to your guns, right? Why didn't you stick to that first point you made about political rights? Why does it matter if not a single person in 1868 thought that? Because we don't live in that Constitution. So like, who cares what they thought? Frederick Douglass, Garrison, the debate. Who cares? The 13th Amendment answers it. That's the Constitution we live under. We don't live under the Constitution of 1789 anymore.
Yes.
Sorry, that was the
Yes, that was, so,
This is why I wasn't invited.
No, it might be the wrong sex. So.
I care very little about what anyone thinks other than my 2- and 4-year-old because they kind of rule my life right now. I was a history major in college, and I think looking at history and social thought and how that all changes is very interesting. But I guess I'll, again, stick to my guns in terms of the words used and the structural changes made to the Constitution. And if the framers of the 14th Amendment wanted Section 1 to apply to men, they should have put it in there. So, working in Congress, there was a lot of things that were said that weren't what was meant. And I guess I have little concern about the intent of certain people in the 1860s or the 1920s. But I did think, and you and I talked about this a little bit, that the Sutherland opinion is very instructive in looking at what, did I go the wrong way? There we go. Of the impact of the 19th Amendment on sort of formalizing the language that was already there in Section 1.
All right. Well, thank you, panel, and now we'll have.
I'm just here to close things out, but thank you everybody for. Is it from you, Ilan? No. Oh, okay, great. Let's hear it. We love you, Ilan.
Is that discrimination?
Don't misinterpret that.
Privilege and immunities clause discrimination?
It's a reasonable regulation.
Yes.
Okay, hi, I'm Carolina. Sorry not to hijack it. Just in terms of why it matters, it's because the verbiage and the wordage, if you were to look back on it, it's not self-defining. So even if you go back to the terms or words that were used at that time, you would not be able to understand or internalize what was meant. Just an example to give you cruel and unusual punishments, even if you were to look back to the exact wordage or the exact verbiage, if you were to look these dictionaries of the time, it's not classified what was considered cruel and unusual punishments. So intent does play a factor. And even if you were to stick strictly to wordage or verbiage of it, there is no way to negate the expectation. Even if you're a pure semantic originalist, there's no way to avoid that without some discretion that is applied. That's great.
I like the reference to the Dworkin Scalia, a matter of interpretation. It's well done, and there's a lot there, and I wish we had, but if you want to say something.
I'll just say, women's groups at the time of the enactment of the 14th Amendment thought that Section 1 would give them civil rights, right? So the people did think that the words mattered at that time. And they were wrong when it went to the courts in Bradwell. And again, we could talk a lot about Bradwell and what it meant and all the differences, but I guess that would just be my response.
Good question, good answer. Thank you.
Well, again, thanks everybody for being here. On your way out, please do grab a card that has our future events. I want to thank Carol McNamara and Isis Gutierrez. Where are they? There she is. She's the bomb. She is the senior director of the center, and everything that happens here is due to her, along with her colleague Isis, who I don't know if she's around, but she was at the front desk. So thank you to my colleagues.
The Post one.
Yes, and Jim wants me to highlight in particular Robert Post, who is the Yale Dean Emeritus, who is coming to talk to us about some misapplied or misunderstood First Amendment doctrine. He'll be here, what date, Jim?
It's the 16th.
March 16th.
February
February
16th.
16th. So it's just 2 weeks from now. We encourage you to come. We'll make sure we have more food, because I think we got a little thin out there. Okay, good. So there's more food. Please do help yourselves. Thank you again for coming, and we'll see you on the 16th if you can make it. Thanks a lot.
Yeah.